Good morning, everyone, and welcome to another exciting episode of Webinar Wednesday. This is truly an encore edition. Our seats here at Webinar Central within the hollowed walls of Employers Group's headquarters in El Segundo, our seats here are still warm from the last time we were here to speak about our topic this morning, which is paid sick leave in California. At that point, a couple weeks ago, we were here talking about the pending implementation of AB 1522, which for the first time ever required all employers in California to provide paid sick leave to all employees. And during the course of that presentation, we foreshadowed our program this morning by briefly referencing AB 304, which was winding its way through the state legislature at the time. And we advised that employers should keep an eye on this. But we cautioned against undue deference to it since at the time we weren't sure exactly what it was going to look like in its final form. And we also thought that it would reach the governor's desk sometime in the fall, and whatever was included in the final provisions would probably take effect in January of 2016. Well, we got it half right. It did pass. But as I'm sure this is not breaking news to anyone, AB 1522 in its original form lasted less than 2 weeks. Because on July 13th, Governor Brown signed into law, effective immediately, the urgency legislation that was passed by the legislature, which had the aim to clarify some of the areas of ambiguity in the law as it was originally enacted. So the question, I guess, that we're all wondering about is, does the amended legislation that we now have provide us the clarity we were hoping to find? Or does it possibly create even more confusion and ambiguity? And this is kind of the overriding theme of our program this morning. And we are, again, immensely fortunate to be able to benefit from the wisdom and the insights of my esteemed colleague, Mr. Matthew Bartosiak. And to go a step further, Matt will be joined this morning by another familiar and respected senior consultant here at Employers Group, Mr. Mark Nelson. Again, the entire team here at Employers Group has been collaborating and trying to make sense of all the nuance of the original legislation. And of course, it's now amended form. We have a lot to share, and I know Matt and Mark are chomping at the bit to get started. But as we get ready to turn this over to Matt, one of the things we had asked the Helpline consultants just to kind of take a look at the calls they've been getting over the last few weeks and do kind of a quick review of that, just to get a sense of what was most on the minds of our members relative to AB 304, the amended legislation. And you can see that the issue of accrual still remains a major topic and still really a complex challenge, as does understanding the options for 2015. And then the other thing we're seeing, of course, the really big item is the issue of grandfathering, which seems to be really the hottest topic these days, and probably where a lot of your questions are going to fall as well. And actually, the more you read the actual legislation, if you have had a chance to do that, the more you read into it, the more confusing it really gets. It's amazing how that happens. So thank you for joining us this morning. We have a lot to cover, of course. We want to be sure to address as many of your questions as possible over the course of the program, and we will do our best to incorporate those into this. So with that, I'm going to turn this over to your friend and mine, Mr. Matthew Bartosiak.
Thank you, Bill, and good morning, everybody. Yes, paid sick leave is probably the most hot subject these days, and we know that it was billed as AB 1522 originally. It was called the Healthy Workplaces, Healthy Families Act of 2014. The posting and notices requirements haven't changed. They were supposed to be delivered and posted on January 1, 2015, and of course the accruals start on July 1, 2015, as the slide indicates. And we're going to be talking about the amendments, especially here, which were delivered in AB 304, and those were effective date they were signed by the governor, which is July 13, 2015. Just a quick review. Covered employers, still no change here. All employers, regardless of size, very few exceptions. Very important to remember, when they talk about a year here, and we're getting lots of questions about that, that's referring to any 12-month period. It could be anniversary, calendar, etc. I'll make a few comments as we go forward regarding municipal ordinances. Please keep in mind that Oakland and San Francisco do have separate laws. I'll be talking about some areas where they are different. San Diego, they went back and forth in San Diego. They had it, they didn't have it, they had it. I think the council even passed it. The bottom line, it is tabled until June 2016. It's going to be a ballot. So those people who are in San Diego and thought you had one and didn't have one, bottom line, waiting to June 2016. All right, the exemptions generally stay the same with a few new variations. Your collective bargaining agreements, they can be exempt, but they have to have sick leave or PTO and any other conditions. Construction industry, generally we're talking about the requirements there regarding the minimum wage, etc. The change at AB 304 in red there in the second bullet, it eliminates the on-site requirement from the definition of employee in the construction industry. So it generally was thought to be on-site. Now that is eliminated. In-home healthcare workers, they are covered if they are publicly funded. Part of the original AB 304, the bill that brought the amendments, attempted to bring in private healthcare workers working for families, individuals. That didn't make it. So as we still progress here, we're talking about publicly funded in-home healthcare workers. And you see flight deck and cabin crew members as that has been staying the same, no change there. Particular change, it excludes public agency retired annuitants. All right, now we're going to talk about who is covered. And here we're talking about the employees. Again, after July 1, 2015, they work 30 more days within a year. Okay. Initially, as the original bill was passed, it said 30 or more days in California. Now you can interpret this to mean 30 or more days for the same employer. I'll stop here for a second and say that perhaps there's a possibility of somebody coming to you and say, hey, I was employed across the street with Joe Schmo and I can prove I was 30 more days there in California. But for all practical purposes, these people are covered if they work 30 more days for the same employer. Oakland, there's a small distinction there, who work 2 or more hours in a week. And the paid sick leave covers all workers, exempt and non-exempt, full-time and part-time in here with per diem employees, seasonal temp employees. So as you can see, by these inclusions of these type of workers, many companies are starting to or had to already incorporate these employees into their paid sick leave plans or write separate sick pay plans for them which meet minimum requirements. All right, let's stay with temp employees for a moment. Temp employees from agencies, most of you out there, you employ temporary employees from agencies. Am I covered if I contract with these people? Well, you have to honor the law if there is a joint employment situation. What that means in plain English is if you, the client, give ongoing daily supervision, you share employer responsibilities with the agency. So you both are covered. If it was me and I was employing people from the agency, I would be sure that they had a paid sick leave policy. And another thing, and you might jot a little note down here, you want to make sure that they have it. And you know what? In your contract negotiations with those agencies, I would be sure that they pay for the paid sick days. Paid sick days. I would make that a part of the negotiation, but that's a contractual item. All right, question, temp to hire. If a temp worked more than 90 days and it's converted to a regular employee, do they immediately get to use sick leave? Yes, they immediately get to use sick leave. If they worked with me as a client and they came from an agency, you have to bridge that time. You have to count that time.
So Matt, in this particular situation, when we talk about the temps, somebody moving over to a regular employee, the law doesn't specifically state this, but really when you read into it, the joint employment is going to mean that it's advisable to the hiring company that they honor the time served with the temp agency. Is that
Yeah,
correct?
that's a quick statement. I would just say, I would just change advisable to that it is mandated. So we're going on to this slide talking about the accrual method. And again, here's the original part of AB 1522, and you can still use this. This is the one that was part of the original law. 1 hour for every 30 hours of work. 1 hour paid sick leave, including overtime hours. You gotta count those overtime hours. No fractions, so you don't give they don't use fractions, they use whole numbers. Exempt employees, as we talked about before, they're covered. And if you don't track exempt employees' time, like most companies do not, you can assume 40 hours work in each work week, unless the normal work week is less than 40 hours. You know, if you work 37 hours, an exempt person, is that your work week, then they work 37 hours. We just did a little calculation here. A 40-hour work week accrues at 1.33 hours per week. Now, look at the bottom bullet with me. Because if you do track hours for exempt, then you have to count all worked hours. And then you're saying track hours for exempt people. Who does that? Well, I've been here since 1980, except for 3 or 4 months. I went to work for Aerojet, and I was an exempt person doing compensation for them. And I had to charge my time to different contracts. So there, in that environment, they knew exactly how many hours I worked, and since they were tracked, if I was subject to this method, I would get 1 hour for every 30 hours of work. Excuse me. And if I was exempt, they would have to count all those hours. We'll talk about the cap here. AB 1522, original law, still can use. There is a cap. You carry over a yearly cap. There's a 48 hours or 6-day cap. Okay, so the cap under this method is up to 48 hours or 6 days. But, and make a mental note here or a short note here, you can limit the use to 3 days, 24 hours a year. So if I have a cap and I've worked up to 6 days, 48 hours, that means the remaining 3 days, 24 hours can be used by the employee the first of the next year. So in this one, for every 30 hours work, there's a cap, there's a carryover. San Francisco and Oakland, the cap, a little difference here, cap must be at least 72 hours for employers with 10 or more employees, 40 for small employers. Okay? You notice the difference in San Francisco and Oakland. They can use sick leave up to the cap at any time. There's no such thing as limiting the allotment of time to be used in any 1 year to a certain number and then saving the rest for later. No, they can use the cap up. They can use all the time up to the cap at any time. This is, okay, we're at AB 304. We're in the alternative accrual method here. Notice that it's in red because this is a change. This is an alternative accrual method. Now, you can use a different accrual method. As long as the employee is on a regular basis and the employee has no less than 24 hours by the 120 day of each 12-month period. Okay? So this allows you to accrue on a regular basis. What does that mean, a regular basis? Not based on hours worked. It could be by pay period. It could be monthly on a regular basis. Now, we still allow cap of 48 hours and carry over the cap. The law is rather silent here, so this assumption on the second bullet, again, is an assumption that I'm making because they haven't stipulated that is now excluded. I would honor the cap of 48 hours and carry over the cap. And you can still limit the yearly use to 3 days, 24 hours. So again, it allows an alternative front load method. I want to make one verbal comment before we go to the next slide, if you will. It's a little confusing because they added this different accrual method twice. Once, if you look at the first bullet, they said on a regular basis, accrues on a regular basis. And then they repeated it as a second option, and they took out the word regular basis. So an assumption can be made that if you take the second option of this alternative accrual method, you don't have to do it on an accrual basis. That's an assumption I'm making. Again, they stipulated this alternative accrual method twice. First, using a regular basis, like pay period, and then the second time they repeated or added this option, they left out the words regular basis, which one can make an assumption. I don't have to do this on a regular basis. That's an assumption. Grandfather plans. Lots of people are talking about grandfather plans, and when we talk about this, you have to remember the word existing. You have to remember the presence of the word existing. Existing policy, okay, if the accrual carryover use requirements are met. In other words, you obey the rule as originally designed, and you had that in place. Or look at this option: the existing policy you had in place before January 1st, 2015, and you gave at least 1 day or 8 hours within 3 months, and then 3 months or 24 hours within 9 months, and you can't lower employee accruals. Now, I have to make a special comment on this grandfather plan option. I went back and forth and talked to many experts and many people interpreting about this AB 304 as to the question of existing policies. What about a situation where I had the policy that met this condition on this slide, but we did away with it? Can I now reinstitute it? Well, here's the sad news. If you read the law, the AB 304, literally, it said you have an existing policy and you did not change it. So if you read this grandfather option literally, you had to have this option as of January 1st, 2015, and have not changed it. So people went back and forth, but if you take a literal interpretation of that, that's what it says. Questions? Well, if I issued a new policy effective July 1st, there's compliance, can I now change it back to what I had in place prior? I think this is the question I just addressed. If you take a literal interpretation of this grandfathering option, you had to have it there before 1/1/15 or as of 1/1/15, and it was still in existence. You had not changed it. And second point here, if it was not compliant with AB 15.2 and I never revised it, under what conditions can I keep my existing plan in place? Well, you'll have to obey the previous slide. Remember those days that have to be earned by certain times, or be compliant with the original AB 15.22 front loading, or 1 hour for every 30 hours. Again, I'm referencing, and those two options, I'm referencing the AB 15.22, the original law. If I provided 32 hours of paid sick leave but accrued over the entire year at 1.65, and did not change it, can I go back to that policy now? Again, you have to go back to the previous slide and make sure you have those days accrued according to the requirements. And that's on the previous slide regarding the 3-month and the 9-month rules on the previous slide. Front loading, again, if you want the front loading, it was part of it, AB 15.22, you can still use it. Again, you're front loading 24 hours or 3 days up front each 12-month period, any 12-month period you want. No carryover, no cap. If you use the front loading method, it's the easiest to use because you don't have to track hours. You just dump these on the employee at the beginning of every year. There's no carrier, there's no cap, there's no tracking hours. That's why people love this, but you're giving people time up front. Remember this last option, please, this last point, please. New employees, new hires can only use it on the 90th day.
And Matt, just to clarify, because the question does come up a lot when we say new hires only use it as of the 90th day, that doesn't mean you have to do it that way. If for some reason you decided you wanted to make people eligible on their first day of employment for their front-loaded paid sick leave, you can do that, correct?
That's correct. You can always do things that are better than the minimum requirements. Yeah, a lot of people say, you mean I can't do this? I can't advantage the employees and go above and beyond the requirements of AB 1522 and or AB 304? Sure, go ahead, do something better. But these are minimum requirements.
And one other thing, just to clarify too, because I know we get a lot of questions on this, that sometimes it sounds like we're saying contradictory things, but for new hires, there is that 90-day option. You can have them wait 90 days prior to having access to their front-loaded paid sick leave. But for existing employees who've already worked 90 days, then they would be eligible immediately if you're beginning to provide this. Is that correct?
Yes, again, remember, thank you, Bill, for that note. Remember, folks out there, that the 90-day requirement that we can make people wait is only for new hires. That's correct, Bill. Existing employees are not subject to that 90-day rule. Let's look at the second bullet regarding front loading. Well, what do I do with sick leave that's already accrued? For the year 2015, it was unclear before, but it seems clear now that you can credit what people had and used in the year 2015, regarding any of the methods, frankly, and especially the 3 days, 24 hours, or inclusive of that. Front loading 2015, how much to provide from 7/1 to 12/31? 1 hour for 30 hours work or 3 days, 24 hours? Well, it depends on your advantages or the disadvantage. Again, the advantages of the front loading is you don't track hours. You dump the time in, okay? Well, gee, you mean I have to incur all that time up front? Yes, but again, new hires can be made to wait for 90 days to use it. The advantage of the 1 hour for every 30 hours work is that they don't have it right away. They have to accrue it. If an existing plan gives full-time employees 32 hours of sick leave front-loaded on their date of hire and subsequently on January 1st of each year, is it already in compliance or will it need to be switched to anniversary date? Again, you pick the 12-month period that you want to use. So what do I do? I think this begs the question, hey, what do I do if I want to do front-loading and I got somebody here that I'm hiring, but I want to switch to a calendar year. Well, from the date of hire to January 1st, you have a requirement to have them accrue either for 1 for 30 hours or give them the 324 on their date of hire. And then on January 1st, you could institute 3 days, 24 hours, again on January 1st. Well, what the heck do I do if I front load on the date of hire? What happens with those 3 days, 24 hours on January 1st? I think it's a washout. I think that on January 1st, you just say, hey, you have 3 days, 24 hours as January 1st. Well, what about the time I already had? Well, it's kind of a washout, Mr. Employee, because, you're limited to 3 days, 24 hours in any 1 year. So, we're just giving it once again on January 1st. So it's kind of a washout if you didn't use it. You're still giving you 3 days, 24 hours. That's at January 1st.
And Matt, we already had a question come in on this. Maybe you can address it now. Prorating. What does AB 1522 and AB 304 say regarding prorating?
Well, no. Forget about prorating. When somebody on the date of hire comes to you, and like this slide says, you want to push everybody to January 1st, well, you either have to front load them again on the date of hire, 3 days, 24 hours, but on January 1st, I'm going to say it's a washout, whatever you use or didn't use, you still have 3 days, 24 hours, because that's where I'm putting everybody. Or you use the accrual, the 1 hour for every 30 hours of work, from the date of hire, use that 1 hour for every 30 hours of work, and then come January 1st, hey, you're going to give them 3 days, 24 hours on January 1st. Well, what happens with that time I didn't use, and since 1 hour for every 30 hours have a cap, can I carry it over? My interpretation is no. Even if I give you 1 hour for every 30 hours of work on January 1st, hey, I'm giving you already 3 days, 24 hours, and again, you're limited to using 3 days and 24 hours in a 12-month period. So forget about what you've earned, carry over under the 1 hour for 30 hours, because I'm switching from your date of hire to January, where I use perhaps a 1 hour for every 30 hours work. Now I'm switching January 1st. I'm just going to dump on you at 3 days, 24 hours, and bottom line, forget about what you accrued before, used before. Because it's a washout, because the reason why it's a washout, because they are limited to 3 days, 24 hours in any 1 year. If I use a system other than front loading, do I have to allow for a carryover? Or do I have to allow for a specific cap? If you use something other than front loading, yes, the way I interpret it, many other people, the caps and the carryover are still in place. Did the AB 304 provide any new clarity as to what my options are? Well, again, we talked about this. Again, I think I'm being a little bit redundant here. This slide talks about what I do with somebody from 7/1/15 to 12/31/15. Well, again, look at the options. You do 1 hour for every 30 hours, right? As we talked about in the previous slide. And then you either continue that option of 1 hour for 30 hours on January 1st. Again, you either continue that and you allow the cap and carryover, because if you stick in a 1 hour for every 30 hours, remember, you're stuck with the carryover and the cap. Or if you use the alternative method, no less than 24 hours by 24 hours by 100th day and a cap of 40 hours. If you use the alternative accrual method, again, the law is silent on carryover caps there, so I am making the assumption that we still be subject to the cap and the carryover under those methods until we get some clarification. And the grandfathered options, we talked about that in the previous slide. And remember, on the grandfathered option, you had to have the thing in place as of 1/1/15 and not have changed it. Or you use the front loading method. Again, we talked about maybe I'll front load you from 7/1 to 12/31/15, and if you didn't use the time, again, on January 1st, 2016, it's a washout, as I kept saying. And if I'm going to the front loading there, then if you still just have, hey, Joe, you just have 3 days, 24 hours on January 1st, 2016, it's a washout. I don't care what you used or not used, because the front load has no carryover. I'm implementing my first 12-month period, which I'm counting as of 1/1/2016, and then I'm probably front load again, or I'll go to the 1 hour of 30 hours as of that 1/1/16. This is a very interesting slide. Can we use different methods, front loading or accrual, or no different amounts? As long as I obey the minimums, right? That's an assumption here. As long as I obey the minimums. Can I use different amounts of accrual for different groups? Yes, as long as it meets the minimum requirements. So you could have one method, for example, and one for non-accepted. Yes, you could use front load for one and 1 hour for 30 hours for the next. Or if you want to be, more generous beyond the minimums, as long as you make the minimums, you can have different amounts as well. Wait, a lot of questions here. Questions, part-time accruals. How do I grant sick leave to a part-time employee that works an irregular schedule or works occasionally a few days per month? Well, interpretations went back and forth. If you use front load, you use front load 3 days, 24 hours. It doesn't matter how much time they work. So if you're using front load, forget it. If you're using 1 hour for every 30 hours, 1 day for 1 hour for every 30 hours of work, then they have to earn up to that amount. And, if you're using that 1 hour for every 30 hours of work, remember, That comes with the carryover, that comes with the cap of 6 days, 48 hours. And if they work a little time, they won't earn up to it. So those people, you follow the bottom line, you follow the rules as it is, but depending on what method you use, they may not be able to earn up to the caps. Payout and forfeiture. You have to remember that sick leave cannot be forfeited by active employees. Don't ask them to sign waivers. Or don't say, hey, which I actually had somebody ask me, no, I'm not going to gross you up because you've chosen not to take a sick leave. And you don't have to pay this out of termination, except if you have PTO, right? Because in California, we have vacation rules, which means that vacation is a wage. And just like a wage, a little bit is earned every day. And the wage concept carries over to PTO. Practically everybody knows you have to pay that out. Now, if they were hired within a year, then all accrued time is immediately available. There's no 90-day waiting period. Okay, there's no day waiting period. But look at the clarification they gave us on the first red bullet. Because the original law didn't do this, but 304 was very clear with us. Hey, if I paid you out, don't come back and say, hey, I had accrued this and I didn't use it, you paid me out for too bad. No, if I paid you out, I paid you out. You get zero when you come back. And regarding the minimum amount required for by law, you know, if you're paying PTO or you're paying vacation, you have to pay what those rates were, what those days were at the time of payout. I'll just make a parenthetical comment. Sometimes people assume that I can pay you vacation or PTO as the rate was earned. So those 3 days when you were earning $10 an hour, I'm going to pay those 3 days. No. And then when you left, you were earning 12. No. You always pay out PTO or vacation at the current rate of pay. Hey, even if the wage diminishes, was lessened. So you could have a vacation payout if you demoted somebody or reduced their pay, paid out at a low amount than what they earned it at because it's the current rate. Okay, counting versus hours versus days. This is a lot of questions. Use hours versus days, whichever yields more sick time. Bottom line, before I go to the second bullet, I'm going to tell you that 3 days, 24 hours, or 6 days, 48 hours, it may fluctuate depending on what the person's schedule is. All right, here's an example. What are you talking about? The employee works 4 days, 10 hours. So what would their be total cap be? And again, this assumes that you're using a system where they earn 1 hour for every 30 hours of work. Well, since the guy worked 10-hour days, then his cap of 6 days, remember, if you're using a accrual method, you got 6 days or 48 hours as a cap. Well, then that 6 days is 60 hours, 6 times 10 days. So when we say 3 days, 24 hours, or 6 days, 48 hours, that might be more time depending on if the days are worth more or the hours are worth more. You have to figure that out. Your work days less than 10 hours, the bottom line, these are minimums. The 3 days, 24 hours, or the cap of 6 days, 48 hours, those are a minimum. So, hey, if my day is, I don't know, 4 hours a day, can you say, hey, three days, in any 1 year, 3 days times 4 hours would be 12 hours? No. The minimum is 24 hours, 48 hours. They don't care if the person works a 4 hour schedule each day, that they only work 4 days. They don't care. So that's a minimum, which might be more if their work day is longer, as seen in bullet 2. Okay, purposes of use. And again, you can see it up there. That hasn't changed. But I want to make a comment here that if your sick pay plan does not cover all these people, like grandparent, look at towards the bottom, grandparent, grandchild. If your sick pay plan doesn't cover these individuals or situations, then you are still stuck with covering these situations and or people for the minimums, for the 3 days, 24 hours. So, hey, if you give, let's say you give, I don't know, 10 days a year. Well, the first 3 days, 24 hours, you'd be subject to this. Anything above that, you'd go back to who's covered. Of course, you'd still have to include domestic partner because by law, under both state and federal law, you have to treat them like spouses. So just make a point here if you would want to. I think it'd be more headaches to me, right, to figure out, oh God, for the minimums, I just have to obey all these things for the minimums, and then we're going to change the covered situations after that if I give better. That's going to give me a hassle, and I wouldn't give myself an administrative nightmare. I just keep the whole thing. But if you push me to the wall, yes, those situations are covered just for the minimum allotment required by time.
And Matt, I'm sorry, just before we move on, there's a couple of questions that come in when we're talking about who is eligible to receive paid sick leave. Just to clarify, independent contractors,
No.
they're not on payroll.
Right.
Okay. So anybody not on payroll, you should not have to worry about.
That's right. And thank you for that clarification, Bill, because it just slipped my mind to mention that because we did get a lot of questions on that. Hey, if you're not an employee, you don't get it. But I got to caution you, members and everybody out there, do you really have an independent contractor or do you really have an employee? Now, we're not going to take time to go through all that. We can discuss that on the phone.
That will be a future webinar Wednesday.
That's probably a future webinar, yes. But if they're not employees, they don't get it. That's correct.
And one other question that's come in, and I know we've received this question on Helpline a bit, out-of-state employees. If I have an employee in Florida, an employee in Texas, an employee in North Dakota, what do I provide to them? What must I provide to them?
Thank you, Bill. You follow the law. You follow the state laws in the area where the person is domiciled and works, where they're domiciled and works. Now you got a situation where they work in California, but they actually live in I don't know, right across the border. Call me, we'll talk about this because I don't want to give a short answer in that situation. I want to make two more comments before I leave this slide. Look at the bottom line, reasons related to domestic abuse, sexual assault, or stalking. All your sick leave, no matter what you give, how much time you give, all your sick leave, whatever you have, has to be allowed for use of this bottom note here, these bottom situations. I'm going to make a parenthetical note here that has nothing to do with sick leave here, but it talks about state laws and are they applicable to people who work in other states. The one I can remember off the bat, being the COBRA expert, is that this is just for insurance. For insurance law, you always obey the insurance law of the state where the plan was delivered and whose insurance commissioner you filed with it. So, for instance, if CalCobra, if your plan was delivered in California and filed with California's insurance commission, even though the people worked in Texas, they could get CalCobra, but that's only an exception generally for insurance law. So, and even then, I think you would call me in those situations, but insurance law has that strange twist where you obey the rules of the state where it was delivered and which insurance commission, relevant insurance commission you filed with. Okay. Well, when are they eligible to use? The employee may use the accrued time on the 90th day of employment. A lot of people are confused about this. Make a mental note, a short note if you're going to get confused. Remember, in many situations, I'm accruing the time from depending on the method I use, right? I'm accruing the time from day one that I can use on the 90th day. Where's their difference? If you front load, second bullet, you can use it immediately. However, remember there's the exception for a 90-day wait for new hires. In Oakland sick leave law, The 90-day rule only applies to people hired after March 2nd, 2015. All right, the law's kind of silent here, but what sort of notice from the employee can I require? Reasonable advance notice. I think it even says that in the law, but you can require a reasonable advance notice for foreseeable leave. Otherwise, if I can't get reasonable notice, if I just fell down the stairs and I broke my, broke something as soon as practicable. I may call you on the phone on my way to the emergency room. Second bullet. The employer may not require as a condition of using leave that the employee search for or find a replacement worker. I've talked with many companies who have that rule that you can't use it here. The law does not address, it is silent on whether the employer may require medical documentation as a condition of using paid sick leave. Now, if you want a real legal answer, talk to your attorney. I think it's reasonable to require medical documentation. Hey, if you, especially been out for a long time, I'm not going to let you start working here until you have a medical visa. I don't know if you're fit for work, right? I have you give the doctor a job description and ask if you can do this job without any modification, etc. But I think that's very reasonable, and I think it's reasonable to ask for medical documentation. Just kind of, when in the real world out there, generally I see a lot of everybody's asking after a 3-day absence. All right. You don't have to ask if you're using PTO. PTO I can use it for vacation and sick leave. It's using whatever reason I wanted. Initially, with AB 1522 being signed, employers were concerned, and they said to me, could they ever have a situation where the guy comes to use all the PTO, we know he used it to go to that big cruise, and now he comes back and he wants additional sick leave because they didn't use it for sick leave? No, the AB 304 clarified. You need not inquire about the recent PTO time to prove that it was used for sick leave. Hey, Joe, you had a max amount of time. I don't care if you went to the Himalayas for the whole amount of time. We've been our minimum for sick leave. I'm not asking why you use PTO. That's the bottom line here. Okay. Can I make them use it in any specific increment? The employees can set a reasonable minimum usage, no less than 2 hours. If you want to let them use it in 15 increments, the law says go ahead. You're being a nice guy. But you can't make me use sick leave in 4-hour increments if I only need 2, right? Partial days are okay for exempt employees with the 2-hour minimum. And this begs the other question is, how do I pay somebody for an exempt person if they use a partial days? And we know that from other rules and laws that as long as you have time in a leave bank that the employee had, you could make up the time missed in that amount. If you want to talk about that further, please call the association. We'll be glad to talk about that. San Francisco, there's a 1-hour minimum allowed. So generally, I can use the 1-hour increments. It's more advantageous for them. There's a larger increment that can be permitted based on certain circumstances. You want to talk about that, I'm going to ask you to call. Oakland Municipal Code does not directly address the issue, but I would interpret it to use increments of not more than 1 hour.
So Matt, as we look at this, we know that if we have a PTO policy and somebody is calling in and say they're not going to be at work, there's no need to ask if it's sick or vacation.
That's right.
Or whatever it is. What if we don't? What if we have a vacation policy and now a new paid sick leave policy, and somebody says, hey, I'm just not up to it, I'm not coming in today? We just take that as it is. Is that correct?
Well, you call me and say I'm not up to it. I'm not coming in. I don't think I'm up to it. I'm not coming in today. What would a reasonable person assume? That you want to go to the beach? A reasonable person would assume that you're sick. Now, you may really be going to the beach, but, if you say you're sick, it doesn't, if you say you're sick or worse to that effect, would count you against sick leave.
And one of the areas that is addressed in, I believe in 1522 is retaliation. So there is protection for the employees against retaliation. So one of the areas to be cautious, and also to go back in a moment, we're going to talk a little bit about handbook policies for paid sick leave. Another policy that is really going to be helpful to go back and look at carefully is your attendance policy, and particularly if you have any kind of disciplinary policy in place relative to attendance, a point system or something like that. Still, as I understand that, not fully addressed beyond the fact that you cannot retaliate against an employee for using their paid sick leave.
Yes, Bill, I think that's on an upcoming slide, but it's nice to introduce it here and remind people, you got to be careful out there. You cannot discriminate people or retaliate or put a black mark next to their name if they use minimum sick leave as guaranteed by law. That's correct. And the law is silent as to whether or not I can count it towards an attendance program. Sometimes people give you money or something if you have perfect attendance. I would not put black marks toward an attendance program for any time that you miss the sick leave that is guaranteed by law. That's correct. And by the way, it probably has it on the slide, but you've got to tell your supervisors and managers and frontline supervisors, those are the people who get in trouble. Everybody in HR administration, you may know the law, but you don't know what the people out there are doing, especially if they're not at a location where you are set, where you are at. So you gotta be very, very careful there. All right, how the heck do I pay this? All right, well, first of all, this hasn't changed. You can pay sick leave in the next regular payroll period. A lot of people don't know this. You can pay the next regular pay period. Just like California has overtime. California's overtime, if you didn't know. I can always pay you overtime in the next at the end of the next payroll period, the one after the one in which it was earned. I can always do that. You can do that for sick leave as well. For exempt employees, you pay in the same manner as employer uses for calculating other forms of paid leave time. Now, as you think about it, one of the problems here is, I am an outside salesperson, and as many of us know, there's no minimum wage requirement there. And frequently, for such people, we just say, if you need the time, you just take the time. So it's an open question. If you don't have employees that have paid leave time or a calculation of a certain wage, what do I do for that? For non-exempt employees, you have two options here. Use a regular rate calculation. The regular rate is a legal term. It does not necessarily mean straight time rate. The regular rate is that rate on which overtime must be based by law. So for an hourly person, that's all money received in the week, including any incentives, directly related to production divided by total hours of work. That's your regular rate. California is different here. The regular rate for a salaried non-exempt person, is a little bit different. It's all money earned in the week divided by a number not to exceed the number of straight time hours allowed to be worked in a week, generally 40. So in an hourly situation, again, I can talk about this personally. An hourly person, all money divided by total hours, and then that's your regular rate. And for a non-exempt salary person, all money earned in the week divided by maximum number of hours, actual hours worked up to the maximum number of hours allowed to be worked at straight time for that industry, for that wage order, usually 40. Or you can divide total pay, again, exclusive overtime pay, total pay, remember the incentives here, for the last 90 days by total hours worked in the last 90 days. Use only full pay periods. You go 90 days, but you don't use partial pay periods. Now you're going to use this a lot for perhaps, you can use this a lot for people who have pay that varies, right? Commission, etc. Regarding San Francisco, you pay sick hour at the equivalent of 2 times the San Francisco minimum wage. But that has to acquiesce to the state requirement if it's higher. And I apologize, but include bonuses, gratuities. Now that is addressed, so I apologize, but take out that last bullet, include bonuses, gratuities, because those are included. As you see in the red above, those incentives are included by law in the calculation of the regular rate. So that last bullet, please take out.
And then there's, just to clarify, because the question did come up, there's no difference whether you're front loading or accruing or whatever method you choose to use. The payout, the calculation of the rate of pay is going to be the same.
That's a very good clarifying question to ask. That's a very good question to ask. And the answer is yes, it doesn't matter. Very good. That's a very good question to ask. Itemized wage statement. You got to show, the law says available. It says show available paid sick leave or PTO on the wage statement. Now, you can give it on the wage statement, you know, that statement that after companies, every check, every pay period, you know, all that stuff you have to do. Well, you're going to have to do it here. But you can also, if it's a hassle, a lot of people say it is a hassle, you can give me a separate document showing available paid sick leave, and you just give me that document along with every paycheck. Now, before I go to the red, it says available. Now, I'm going to suggest, as a lot of people suggest, is you're going to get a lot of questions that say, hey, I haven't this accrued and blah, 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 blah. If you're in a situation where you have accrued but it's not available yet, I would go above and beyond. Not required, but I would go above and beyond. I have 2 columns, 2 pieces of information, accrued but not available and available. But if you push my back to the wall, the law uses the term available. Now, AB 304 clarified that if you have unlimited sick pay, just put unlimited in that box. You know, a lot of people queried us about that. The itemized wage statement, this slide, this requirement to put on available on these pay stubs or in an accompanying document, that is delayed until January 1, 2016 for motion picture and broadcasting industries, wage orders 11 and 12. And if you're not sure what wage order you're covered under, any consultant at the employers group can help you.
And Matt, as we move to the next slide, another question had come in. I think you pretty much addressed it, but just to clarify, which is in the 90 days, if we're going to wait 90 days before making the paid sick leave available to a new hire, on the pay stub, is that specifically addressed what we need to do? Your advice is to have 2 columns.
If
it's available, but is it addressed at all in the legislation either way?
Thank you, Bill. If you push my back to the wall, it says just show available, so I could say 0. To avoid 100 people coming into my office, I would be accrued but not available and available. And that's just another clarification. There's your revised wage poster. Labor Commissioner has provided the wage disclosure notice. It's right there. And remember, this wage disclosure notice, this is the same darn thing that you give to non-exempt people. It says all employees, but you only give it to non-exempt people. That's the wage theft protection notice. That's required. It's been required for a long time. But the one that's changed that includes information on sick leave, that's required 1/1/2015 for all non-exempt employees. Yes, that was funny that they made that requirement effective 1/1/2015 when you actually didn't start accruing it to July 1, 2015. And you had to post it by 2015. There's your link regarding, I don't know if I said it on another slide, but what do I tell exempt people? Well, the law says that if you made a change to existing policy, you had to tell people, to comply with the law. You had to tell people about it within 7 days. You know what I would do? In addition to giving this notice to non-exempt people, as I have to the wage theft and protection notice, I would just, you have to, if you change it, send it out. I would just, to avoid all problems, just publish the sick leave, changed or unchanged, and say, hey, here's an email, the post is down the hall, and here's an email of sick leave. It's been changed to comply with AB 1522 and AB 304, or it's not changed and it's always been compliant. We get out of here and do it that way. And it's also found in your handbook. All right, penalties, they can file with the labor commissioner. And for retaliation, again, we talked about retaliation. Be careful you talk to those managers. And here's your thing that you can be liable for the dollar value of sick leave times 3 or $250, whichever is greater. Your maximum is $4,000. Other harm, well, other harm means if you discriminate against me or you don't promote me, something like that. And those could include civil penalties up to $50 a day that you didn't give me that promotion, or raise up to $4,000. Hey, and they're going to zap you one more time. Look at the last bullet. They can also say, hey, we had to do all these expenses, the labor commissioner's office, so it took us a lot of time, so now we're going to charge you $50 per day per employee because of all the investigation we had to do. So they're going to zap you a lot.
Matt, you mentioned talking to supervisors and managers, and obviously there's so much nuance to all this stuff, so we can't really expect them to understand this, because even for those of us whose job it is to understand all of this, we're going to be struggling with it. So probably the best way to communicate this to supervisors and managers is through your policy, your written policy, whether it's through a policy procedure manual or through an employee handbook. And we've been getting tons and tons of questions on this. So we asked Mark Nelson, our senior helpline consultant, to step in here and talk to us a little bit about some of the policy considerations that he has been working on with many of our members. So Mark, I'm going to turn this over to you at this point to go through handbook policy considerations.
Thanks, Bill. And like Bill said, we do work with a lot of member companies to address policy considerations when it comes to their paid sick leave, especially in light of the new law. A few considerations have kind of risen to the top in terms of concern for employers, and for that reason we wanted to address those with you in this presentation. The first and foremost I would have to say is, do you have a separate sick leave and vacation benefit? As we know, the state considers vacation to be wages and must be paid out at termination. Sick leave is not, even with the passage of this new law, so it's not paid out at termination. But of course, when you roll everything together into a PTO policy, which begs our second question here, then of course it's treated like vacation. Vacation is earned as labor is performed in California, meaning you cannot have a policy where you gift, say, 2 weeks on January 1 of that year, and if the employee terminates December 31st of the previous year, they earn nothing. In other words, they would earn essentially the full amount of that, because vacation vests as the employee performs the labor attached to that vacation. And for that reason, accrual policies may be more beneficial for PTO policies, because of course it's per hours worked or per pay period if you're looking at one of the alternative accrual methods. But in terms of front loading, that may be more problematic if you have a PTO policy, since, like we said, vacation is very specifically treated in California. Essentially, the second question and the first question are tied together, so I will skip to the third policy consideration here. Do you have paid sick leave as of January 1, 2015? As you heard Matt talk earlier, if you have had a policy in place as of January 1, 2015, then you may be eligible for the grandfathering provisions that are now in effect. And if you hadn't, then of course that excludes that opportunity for you to participate in the grandfathered policy. The fourth consideration: does your current paid sick leave policy exclude any class of employees? A lot of employers have made only cosmetic changes to their paid sick leave policy, forgetting that the new law extends that benefit to all employees, not just your regular full-time employees. We see a lot of policies, or saw a lot of policies prior to the enactment of this law, where part-timers and temps were exempt from participation in paid sick leave and other benefits. At least for paid sick leave now, you cannot exclude part-timers and temps. Matt did talk about having different accrual rates and methods for those individuals, so I will defer to him on that. But note that all employees must have access to paid sick leave per the minimums delineated in this law. Does your current policy limit use to an employee's own illness? In other words, prior to the enactment of this law, a lot of employers had sick leave benefits that were limited to being used for the employee himself or herself only, except in the case of kin care, which is of course a law in California that says if you have available what you would earn in 6 months' time or half of a year's accrual of sick leave, then you can use that for a family member as defined in kin care. But if you limited all other vacation usage, we now know that paid sick leave per the new law extends to the family members that Matt was talking about earlier, as well as victims of domestic violence. That kind of goes to the next question, which is, do you still reference kin care in limiting terms? We now know, of course, that the definition of family member expands beyond the old kin care definition, and you want to make sure that not just your paid sick leave policy has been amended, but if you have a separate section on kin care, that you look at that language as well. Do you want to reserve the right to request a release to return to work? Matt talked at length about this. We don't know the answer to this question. This is definitely one of those situations where when you're distributing your policy, before you publish it to your employees, we always recommend reviewing that language with your employment law counsel. And this would be one of those cases where we would recommend, does your employment law counsel consider it necessary to reserve that right so that it looks like it's part of your policy, and state that explicitly in your policy, or does your employment law counsel consider that something to exclude altogether from your written description of your paid sick leave policy? Again, big question mark there. We don't know where that's going to necessarily be going. Another question is, how frequently do you revise your employee employment policies and or your handbook? If you're referencing language specific to this year, the year of enactment of this new law, if you don't revise your employee handbook frequently and that language is still in there several years later, then that might look not so attractive for your for your detriment. In other words, a plaintiff attorney seeing that a company does not revise their handbook on a regular basis, at least every 2 years, we prefer one, or when there are new changes in the laws, that might be problematic for you, because it makes it look more attractive for plaintiff's counsel, or it may look more attractive for plaintiff's counsel to know that you're not keeping up with things like the handbook. Maybe that suggests you're not keeping up with other compliance considerations as well. How are you bridging the initial implementation period? If you did not have paid sick leave and are now introducing it, how are you handling it? Matt talked about proration earlier as well, and concerns about utilizing something like that, as well as policies where you've already granted paid sick leave before July 1 of this year. All of these policy considerations should be taken into account when you're updating your policy handbooks, or your policies and handbooks, if you haven't already done so in light of this new legislation. If you have any questions, of course, we're always available on the helpline to answer them, so feel free to give us a call. With that, I will turn it back over to Bill and Matt.
Thank you so much, Mark. That's really, really good practical advice. And I want to play off of one thing you referenced relative to the plaintiff's attorney, too. And I always think back to several times over the last few years, we've had a plaintiff's attorney speak at our employment law update. And he's very, very quick to point out that when he gets a call from your company, the first place he's going is your employee handbook. And that, well, we call it a handbook, he calls it a gold mine. So I always think that that's an important insight for everybody to take into account as they look at their policies. And I can say that we looked at a lot of policies heading into the July 1st deadline on this, and I don't think we saw a single policy that really was ready for AB 1522. And I don't know that much in terms of the policy is changing now with AB 304. The policy needs to be written, but obviously there's a lot that needs to be taken into account. The paid sick leave policy that you now have to have in your handbook is critical, but also take this opportunity to look at your entire handbook, and particularly policies that may interact with paid sick leave, which, as we already referenced, absentee policy and other vacation sick leave policies that could be part of this, and disciplinary policies as well. So thank you so much, Mark, for those insights. We really appreciate it. And Matt, I know you have a couple other really, really useful tips that you want to share with everyone.
Yes, thank you. Well, here are some compliance tips you have to be sure. Obviously, you're going to decide which option the company is going to use regarding quotas and caps. Remember your 4 options that was discussed. Definitely review, even if you're thinking compliance, you may have to revise existing paid sick leave or PTO policies and procedures to ensure compliance. The big one is number 3. Remember, as we said earlier in the program, you probably are going to be writing sick leave policies, different ones, or include them in existing ones that are compliant for your part-time employees, your temp employees, and seasonal employees. And remember, your seasonal employees who come and go, just a marginal note here, these are the people who might come and come back. You don't have PTO, if you have sick leave rather than PTO, and they come back with time on the books, so you have to remember that. Again, obviously, if you're in San Francisco, Oakland, or perhaps San Diego after June 2016, you have to look at the ordinances and make sure that they integrate. And remember, as always, in most laws, where there are contradictions, where there are differences, you have to obey the law, the rule that gives the employee the better break. And again, we can't stress this too much. I think Bill introduced it, and I talked about it briefly. Anti-retaliation. You have to look, not just your sick pay policies, put a star across this or next to this bullet. Your attendance policies, your conduct, your discipline, your attendance bonus. Again, you have to make sure you do not discriminate, retaliate against people who use what is guaranteed them by law. And of course, second bullet, you have to do the notice and posting record keeping requirements. Generally, your record keeping requirements are for 3 years. You have to monitor the developments according to the state. Again, if it was me out there, I would be probably publishing my sick leave for everybody, saying, hey, here it is. It's on the poster. It's in the handbook. Here are changes that we made to be compliant, which indeed you have to notify all people within 7 days if you did make changes to be compliant. If you get it out of my hair, I'm going to do it anyways. Again, please determine how you're going to meet posting requirements, especially posting requirements for off-site people. You know what most people do? They put them in a binder, put all these posters in a binder and send them to get out of your hair. I'll email them as long as I would email them. I would like them to be able to be downloaded. I think that would be very important. And you have to use the Wage Theft Protection Act notice that has the information about sick leave. Again, even though the law says all employees, that's really only effective for non-exempt employees. And again, as I said earlier, you had to use the amended Wage Theft Protection Notice as of January 1, 2015. Remember, we said that on a different slide. Benefits, timekeeping, payroll systems are ready to properly calculate, track, report, accrued and unused. Again, the law says, well, you're going to have to keep records of accrued so you know what's eventually available, etc. But just be prepared for these record-keeping requirements. Remember, if you don't want to track hours, go to that front load method. or you could use a one of those two new methods. Remember the ones we talked about in the previous slide, where you gave time on either a regular basis, like payroll periods, or assume that you don't have to do a regular basis for being compliant. And that assumes that I could drop some time on your head at a certain time. If you want to do something like that, please call us. Again, the second bullet should make sure that the information shows what's available. I would do available and accrued. Train those supervisors. And again, lastly, monitor the website. They're supposed to update those FAQs. Originally, they had FAQs. I haven't seen them updated yet. I look every day for it. And they'll give other guidance information on the DLSC website. Again, here we go with another question, potential misuse. I think we talked about it earlier. Can we require doctor's note if the employee wants to use 2 or more consecutive days of paid sick leave or wants to use a paid sick day before or after a paid holiday? Well, again, the law is silent. If you want a straight legal answer, you can ask your attorney. I think it's reasonable to ask for proof of sickness. You kind of ask what the heck is wrong with the person. But after a series of days, usually we find that in most companies after 3 days. And I do know of companies that say, hey, if you're sick before or after the paid holiday, you don't get holiday pay. Sometimes they want a sick leave notice. They want a doctor's certification there. I just put in the holiday here to just remind you that if you have that rule about paid sick days, and not getting paid holidays, if you use a sick day before and after, you cannot apply that to an exempt person as long as they work part of that work week. You can apply that rule and not to an exempt person as long as they had performed work in that 7-day legal work week.
And Matt, another question that's come up a little bit is looking for patterns. Obviously we see this in certain industries around holidays. People are going to be looking to take more time off. We see the patterns in the Mondays and Friday call-ins for sick. There's nothing in 1522 or 304 that specifically forbids us from looking for those types of patterns and addressing those. Is that correct?
Yes, I still would look for patterns because if people would look for patterns with one caveat. You have to be careful about depriving or disciplining people for using what is guaranteed to them. So what's up in the air, perhaps, is if you have a pattern of somebody calling in every Monday or something like that. A safe caveat would be is to, at least for the minimum required, be very careful about discipline or discrimination. I'd be very careful about that. I'd be looking at patterns above and beyond. Here's the bottom line. Here's the bottom line. Above and beyond that amount of time mandated by law. Have you checked your payroll? Are your pay stubs in compliance? And Bill always says this thing when we're doing these presentations, check with your payroll company. Make sure they're prepared for this. Electronic paychecks and employee access. Again, you can do electronic paychecks, you can do electronic stubs, as long as they're able to be downloaded. And I cautioned you several times about attendance programs and not counting against attendant program participation for time missed that's guaranteed them by law. Grandfather, can we reinstate a policy? I would not. If we take, and I went back and forth with this with attorneys. Regarding that grandfather option, it has a separate slide. If you take a little reading of that, you have to have had that in place prior to 2015 and never have changed it. Asking doctor's notes, it's absolutely silent again, absolutely silent. I would be reasonable, most people do it, as I said before, 2 days. Prorating available, generally no. If you use the front load, you front load. Doesn't matter. If you use front load, it does not matter what the schedule is. If you use accrual, went out to 30 hours, so they're going to accrue according to that schedule. It's just straight mathematical calculation. If you use one of the options we previously discussed by giving a certain amount of time by certain days, don't prorate that. Remember the one that if I give you certain, what was it, 1 day, 8 hours by the 3rd month, and 3 days, 24 hours by the 9th month. I think that's what that slide did. Refer back there. That can't be prorated. Well, we talked about it. When will it be updated? Well, we're looking for this FAQs to be updated. The bureaucracy in government always makes this stuff lag behind when you need it. Makes clarifications lag or available or published after you already have to comply with the law. That calls for letter writing. Why are you guys so slow? And we'll let Bill close this down.
Once again, just want to thank everybody for their participation today. Thank you for your questions. We did our best to get all of them addressed in the course of the program, and I think we did get pretty much everything addressed that came into us over the last hour or so. So thank you all for being part of our presentation today. The final slide indicated that there's still quite a few things that we don't know about this. Please stay tuned, monitor the DLSE website, stay in touch with your friends here at Employers Group, where our job is to keep a close eye on this and to keep you informed of this. We will be sure to share every bit of information the moment we get it. Stay in touch with our hosts today, Matt Bartosiak and Mark Nelson. Finally, just to thank the two of you, Mark and Matt, for a wonderful presentation, all the great information. We really appreciate all the effort that you've put through to make this such an informative session. Thank you, everybody.